Cool. Okay. Hopefully this is working. I don't know if it's working or not. I am attempting to re-record Money, Trust, and Responsibility, a Fiduciary's Playbook, which is a webinar that I presented yesterday on Black Friday, but that we forgot to record. So I am re-recording, or actually recording this time, so that I can send it to the folks that registered but who were not able to attend. I figured that since I need to do it again anyways, I might as well try and do it live, so that other people who are just browsing through Facebook can stop in and learn something. So that is what we are doing. That is what I'm going to be talking about for the next 40 minutes or so. My name is Whitney Lee. I am the founding attorney of Wills for the People. And I do estate planning and probate support for folks here in Georgia. My practice is virtual, and I work out of my home office and travel to meet people, but also meet people virtually via Zoom. I'm also the host of Impostrix podcast, where I talk about overcoming imposter syndrome as a professional of color. So, today, like I said, we are doing a recording of a webinar that I did yesterday, but that I forgot to record. And so, we're specifically going to be talking about what are the roles of an estate plan. Before I get started, I want to talk a little bit about what my practice does, who we are, and why we are. First, let me say that we are a year and a half old. We'll be 2 years old in the spring. I am an ex-civil rights attorney and legal aid attorney, and I've been practicing for 12 years here in Georgia. Went to school in Seattle at Seattle University School of Law. Um, Over the past year and a half of focusing solely on estate planning and specifically focusing on communities that where legacy building is not necessarily within our culture. I have served upwards of 50 clients, including couples, with a whole range of estate planning type support as well as probate. So that means I help people both get their wills and trusts and powers of attorney together and in order. I advise them on how to meet their goals and their needs as far as legacy building and taking care of their loved ones. And then I also, if someone has passed away and that estate needs probating here in Georgia, I represent families to probate the estates or to get guardianship or conservatorship over loved ones who are not able to care for themselves. So that is what I do. I have a 5-star rating on Google Review and encourage folks who are looking for an estate planning attorney to consider my firm so that we can help you out and work with you in a language and in a way that you can understand, that you can feel confident about. All right, so jumping into the presentation. There are many reasons why people may plan their affairs or why they may do estate planning. Protection, creating legacy, and then also creating a path and a plan for your loved ones who are going to kind of pick up where you left off or who are going to be the beneficiaries of whatever type of legacy you're leaving behind. What's important to note, though, is that getting the estate plan done is just one part of the puzzle. There are several parts of the puzzle that include coordinating with financial advisors and with insurance reps to make sure that you have other products that are a part of your estate plan in addition to your will and your trust. But then also, it's so important that you're communicating what your goals are with your estate plan, that you're communicating to the people who have a role in your estate plan about what all is going to be going down. What is their role? What are the duties or responsibilities under that role? Is there any liability that they need to be concerned about? Who are the people that they can hire to help them with that role? Those are all the types of questions that you want to make sure you can answer for your loved ones, I do not suggest just kind of springing this on people. They should be aware that they have a role in your estate plan, and they should be aware of what your goals are when you put that estate plan in place. So, yesterday, when I did this webinar, folks who attended were folks who were named to play a role in the estate plan, folks who had created an estate plan and they wanted more clarity and more language, maybe to pass on or convey to their loved ones about what the duties they were giving people are. And then maybe you need to create an estate plan. And so you're just wanting to know what are the basics of estate planning and how do I choose who is going to have a role within my estate plan. So during this presentation, I'm going to answer those questions and I'm going to go into detail about what these roles are and what are some considerations that you should take when deciding who is going to have a role in your estate plan. So I had already mentioned that there are a number of reasons why we might plan. I want to get a little bit more specific. So if we have a family that we are leaving behind, then an estate plan does a great job at making sure that our spouses, our children, and our other loved ones are provided for. If we do not have a plan, then the state of Georgia has a plan for us. We may or may not like that plan. So by taking the affirmative steps of having an estate plan, we have more control over how we are going to provide for and protect our loved ones. Also, we might have an estate plan because we have young minor children and we want some control and to provide some protection as far as how they can receive the money, when they can receive the money, and making sure that they're not wasting or basically spending the money in ways that we might not approve of and in ways that might end up not passing on our legacy. So, in other words, I don't want to leave any 18-year-old $100,000 because I'm 38. And if I had $100,000, a lot of it's not going to the responsible things, right? So when we estate plan, we can have more of a say as far as when we can access the money, when the beneficiaries can access the money and what they have to do to be able to earn basically or be eligible for their inheritance. And then lastly, we might plan to avoid taxes, to avoid the later expenses, like the expenses of going through a probate process, the legal fees, the court fees, etc. And maybe we want to keep our family in good accord with each other. We want to avoid family fights. Unfortunately, many folks have experienced this, that as loved ones pass away or become ill, we have different ideas about how to best support those people. So by putting an estate plan in place, we are able to say how we want to be supported if we are incapacitated and can't make decisions for ourselves. But we're also able to say definitively what we want to happen with our assets so that there is no guessing regarding, okay, what do I want to happen with my estate plan? However, we also need to be thinking about ourselves when we are doing our estate plan. Similar to when we are on an airplane and we are flying to go visit family or loved ones, maybe over this holiday break, and the stewardess and the flight attendants say, put on your mask, your oxygen mask, before you help the child next to you. We need to take a similar caution when we are doing our estate plan. We need to be concerned about who has our back in our estate plan, who is in control and in charge to make sure that the message that I leave that says, hey, I want my kid to be taken care of this way, or hey, I want this money to be used in this way. We need to make sure that we're doing what is necessary to make sure that those wishes are actually carried out. And the only way that we can do that is if we are actually communicating that through our estate plan. So it's really important that we do that. All right. So again, for folks, if you aren't happening to join me, this is a little bit weird, a little bit awkward. Basically, I did this presentation yesterday. We talked about what are the roles of an estate plan. It was an hour and a half long conversation. It was great, but I forgot to press record. And we had about 55 people register for that. Many people were not able to make it. And so I wanted to actually record the presentation so that it can be sent to the people that are interested. And I thought to myself, well, instead of just talking to myself in an empty Zoom room, why don't I share this live? So that's what I'm doing. I'm a podcaster. I'm okay talking. I'm an extrovert. It's fine. If you are listening though, and you have a question, you could feel free to put that into the Facebook chat because I think I've got my page in a way so that I can actually see that. I'm not 100% sure about that, but I think I figured it out. All right. So what am I doing? Estate planning 101. Before we get into talking about what the various roles are of estate planning, I do want to talk about what are the basic foundational documents that are involved when we are estate planning. And so when I say those words, estate planning, primarily what I mean are your last will and testament, your revocable living trust, and your power of attorney documents. There are other aspects of estate planning. It can be as in depth and complex as you need or want it to be in order to make your goals a fruition. However, those kind of first few documents that most people are thinking about putting in place are the will, the trust, and the power of attorney documents. So those are going to be what I am specifically talking about today. What is necessary to make sure that those wishes are actually carried out. Okay, turns out I can hear myself live. Great. All right. Nope, I didn't do that yet. So first, the last will and testament. This is the document that allows you to distribute your assets to whoever you say they should go to. This is a great foundational document, but there are some limitations. So first, consider that a will is basically a letter to the judge in that, yes, you are laying out what you want to happen to your estate plan or with your estate plan. However, everything that you leave in your will is going to be approved by a judge. The judge is going to be giving permission to the executor who you have named in your estate plan to do the things that your will says to do. All right. So you're distributing your assets. You're also choosing the guardians for your children. This is very, very, very important for people who do care for minor children or who care for dependents. So maybe adults with disabilities. This is the document that says who you prefer to be those children's guardians if you pass away and they have no legal parent left living. Now, this is a nomination, meaning you are telling the court, this is who I want to do it, but the court is going to be considering what is in the best interest of the child when actually appointing that person. However, it's still important for you to make your desires known because if you don't, then you're just leaving it up to other people to say, oh, hey, Whitney really liked that girl, Sarah. Sarah seems like she's great. I know the kids call her Auntie Sarah, so Sarah should be the guardian. Okay, so making sure that you are using your estate plan to communicate to the court and to everybody else what you want to happen is so vital because we're not mind readers, right? Like, and you're gone, so we can't ask you what you want to happen. And then your will also allows you to choose who your executor is going to be, and then your backup executor. The executor is the first role that we're talking about now, and it's the person that is responsible for carrying out the wishes of your will. They are the people that are going to take your will to probate court. They are going to file a petition for letters testamentary, is what it's called here in Georgia. And they're going to file the petition that says, I would like to probate this will. They are going to appear before a judge. They are going to talk to the judge and other court officials about what your will says. They are going to present the will. The judge is going to say, okay, this is a valid will, or nope, this is not a valid will. And the judge is also going to hear any objections to your will. So if you have loved ones or family members who basically want to contest the validity of your will, or want to say that somebody forced you to make this will, or that you were intoxicated or inebriated, or that you did not have the capacity to create a will, it's the executor that is going to be representing your estate in trying to get this will recognized by the court. So it's really important that the person that you choose for your executor is capable of doing the various tasks, which is the purpose of this webinar. So we're going to come back to the executor. But before we do that, we're going to talk about another document that is foundational for an estate plan. That is the revocable living trust. The revocable living trust is basically a will on steroids, in that it gives you more control over how you leave your assets to your loved ones, to the beneficiaries. You get to control when somebody gets the asset. So you can say, my brother Jordan does not get my inheritance until he is 45, or my child Everett does not earn his inheritance until he is 25. And even when he's 25, he has to have graduated from a 4-year college and taken a financial literacy course. Okay. You can have various conditions within your trust document, and that trust is a contract. So, whereas the will is a letter to a judge saying, this is what I want to happen, the trust is a contract with yourself as the trustee. And because it's a contract, it does not have to go through court, which means one way that people skip the probate process altogether is by putting this revocable living trust in place. Anything that is owned by the trust, any asset that you have taken the affirmative steps to transfer to the ownership of the trust, can bypass probate after you've passed away. The trust is highly customizable, and it also is in effect both after you've passed away, but also while you're still living and you're incapacitated. That's another great benefit of the trust that you don't get with the last will and testament, in terms of what is happening if you're not able to care for yourself and therefore not able to care for your assets. A trust has these built-in provisions that allow your successor trustee to step in and manage your affairs for you. We'll talk more about that later. Okay. And then finally, I want to talk about the powers of attorney documents. Here in Georgia, we have 3 main power of attorney documents. The financial power of attorney, which is sometimes just called the power of attorney. If you're hearing like that language, usually people are talking about the financial power of attorney. There's a healthcare power of attorney, also known as an advance directive for healthcare, also known as a living will. Then there's the psychiatric power of attorney, which is great for people who have mental illness or psychiatric diagnoses, where maybe they have periods of incapacity, essentially, where they need somebody to step in every now and then to be able to assist them with getting the care that they need to restabilize. So in each of these documents, you are deciding in advance who you want to be the person who is authorized to make decisions on your behalf if you cannot make those decisions for you. I mean, if you can't make the decisions for yourself. So what that means for the financial power of attorney, you are authorizing someone who we call the agent to make finance and property related decisions for you. And that healthcare power of attorney, you're authorizing the agent to make health and medical related decisions for you, including contracting with doctors or other medical facilities, transferring you or discharging you from an institution or facility, talking with your insurance to see what's covered, making those types of decisions. And then the psychiatric power of attorney is a little bit different in that it's very, very detailed. If you are the person that is doing the form, you are specifying what you want to happen if you are experiencing a period of incapacity. So Do you want somebody to force you to take your medications? Are there specific doctors that need to be contacted? Are there specific law enforcement officials who need to be contacted? Um, what do people have permission to do, and what under no circumstances do you want to happen? So those are all great documents. They're all really crucial. In my opinion, the healthcare power of attorney is the most important document that we can have, because we're still living. These documents are all active, they're alive, they're good while we are living. And once we have passed away, they are no longer really helpful. Okay. So they're so important, in my opinion, because if I'm still living, then I want to be cared for the way that I've communicated in my estate planning documents. If I don't do these documents, then I have no way of having communicated what I want to happen and how I want to be cared for and how I want my assets cared for. And people are just going to have to guess. And what's more, loved ones may have to go to court to get what's called a guardianship or a conservatorship, which is a court appointed person who is basically managing my physical health as well as my assets. Okay, I do see that there are some people watching. That's kind of cool. So if you are watching and you have questions, you can feel free to put it in the chat. I can see the chat. All right. So what are the various roles within the estate plan? What are these roles that I've talked about? There's the trustee and the successor trustee. That is applicable to your trust, whether that is an irrevocable trust, which we are not talking about today, or that's the revocable trust. There's the executor or the personal representative. That is the person who is carrying out the wishes of your will. Here in Georgia, a lot of times it's called an executor, but in other places, a personal representative is kind of the default language. There is the agent for your power of attorney document. The agent is the person who is authorized to do the things that you have authorized them to do. And then there are the people who are authorized to get your medical records under the HIPAA authorization, the Health Information Privacy Act plus another A. I don't know. I don't know what it stands for. I don't remember. But it's the medical record release. Okay. So it's the people who are authorized to access the medical records through that document. And then there's the guardian and the conservator. Those two are the court appointed roles that I've discussed to some extent, where someone is alive, they're incapacitated, but they do not have powers of attorney in place, or maybe they're minors, and so they can't choose, and their parents or caregivers did not specify. No, they may have specified who they want to be the guardian or the conservator, but the court still has to go ahead and appoint that person. Okay, so those are the main roles that we're going to talk about today. All right, so let's talk about the successor trustee. And I like to think about these roles as chess pieces. And if they were chess pieces, then the person who is creating the estate plan is the king. The most important piece, if I die, then the game is over. And we have all of these things, all of these pieces that are going to protect me, but also that are going to protect my estate. Okay. So the queen then is the successor trustee. While you are alive, if you have a revocable living trust, you are the trustee. You are the trustee and you are the beneficiary. So you are still in control of the assets that are owned by your trust. But if you become incapacitated, meaning you can no longer make decisions to care for yourself, you can no longer care for your assets, or you disappear or you're incarcerated for more than 30 days, you are incapacitated. If you become incapacitated, the successor trustees step in to manage your affairs in the way that you've specified within your trust document. Additionally, Successor trustees will step in after you have died to carry out the wishes of your trust. So the successor trustees for incapacity can be the same as the successor trustees for death, or it can be two different groups of people. It can be one person, it can be multiple persons. It can be a professional fiduciary, so maybe a CPA or a lawyer, or maybe you have a financial institution that has a trust department. They have professional trustees that you can pay to basically handle this business of being a trustee. Or it can be a loved one or a friend or another layperson. There are various times where you might choose that the trustee should be somebody that's hired and a professional over a layperson. You would want to like talk that through with myself as your attorney or whoever you're hiring to do these documents and advise you through this process. So, what is important to know though is that your trustees need to be somebody that can be trusted with the information about the assets. Because since their role is to protect the assets and distribute the assets, they need to know what the assets are. They need to know how to access the assets. Okay. Also, it's going to be the trustee's role to make sure that the beneficiaries know what to expect with regard to the trust. So that can mean that the trustees are providing a copy of the trust document to the beneficiaries and otherwise communicating, okay, well, yes, you do have an inheritance coming, but you only get the inheritance after XYZ condition is met. Here are some of the other roles of a successor trustee. And these are, I shouldn't say role, these are the responsibilities or the duties. So providing copies of the trust, notifying the banks, the insurance companies, other entities of your passing or of your incapacity and letting them know that like, hey, I'm the person now. I'm the queen. I'm deciding what's happening based on what the king said in their trust. And so everything should come through me. The trustee is authorized in many cases to hire other professionals to help them with this role of being the trustee. So that means they may hire attorneys, CPAs, and other financial advisors. They may hire a tax preparer because one of their roles is filing the annual tax returns on the income of the trust. Or if it's a high net worth individual, the trustee's role is going to be to file the estate tax return as well. The trustee is going to track any expenses and particularly expenses that they have paid for out of pocket that need to be reimbursed. They're going to pay bills and debts. They're going to handle any investment decisions, and they are going to be basically monitoring and distributing assets for any ongoing trusts. Okay, so that's if we have a trust that is going to continue long after I'm gone, because maybe it says, I want my 8-year-old child to receive inheritance in 20 years when he's 28. That means if I were to pass away today, my trustee is going to be responsible for managing my trust for the next 20 years until they're able to pay out my beneficiary in the way that I've specified. The executor role is similar to the role of the trustee, with the key difference being that the executor is dealing with the will and the court, and the trustee is dealing with the contract of the trust. Sometimes an executor is going to be the same person as the trustee. Sometimes it's going to be two different people, and that's fine. The executor, because they're dealing with a will, their role is going to court, filing the will, requesting permission from the court to do what the will says to do. Sometimes, well, every time, if you have a trust document, then you're also going to have what's called a pour over will. If not everything is owned by your trust at the time that you pass away, then it's likely that the executor is going to have to take some additional action to probate your will, even though you have a trust in place. That is because your trust is only passing the assets that are owned by the trust. This is where we, as estate planning attorneys, see a lot of trusts that just don't mean anything, because you'll make a trust on ChatGPT, but ChatGPT doesn't tell you that you have to actually take affirmative actions to fund the trust. Or you'll go to Susie Orman or the other dude where you can buy a $200 trust, and it gives you the form and you plug in the information on the lines, but it doesn't tell you what else needs to happen in order for the trust to actually do its job. So if you have a trust, but nothing has been funded to your trust, in other words, your trust doesn't own anything, then that means some of those assets are going to have to go through a probate court process, unfortunately. All right, so your executor is the one that's going to be doing that. The executor, so I don't know why I put this, because in reality, the executor does not usually handle the burial and final disposition unless they know who they are and they know they have the authority to do so. That is because on the healthcare power of attorney forms, there's also a direction around final disposition and burial. And oftentimes we're saying that we want, in those documents, we're saying that we want that person, the healthcare agent, to actually handle the final disposition, making sure that our remains get to where they're supposed to go. And then the will might not be read until a couple of weeks later. Either way, we are putting, what we want with our remains, what we want to happen at the end of our life, after our life, we're putting that in our will, and then we're also putting it in the advance directive. I don't see any questions. Okay. I'm just typing in the chat if you have them. I'm having deja vu. Okay. So then we've got the power of attorney agent. The power of attorney agent is the person who has been authorized by the person completing the form to be able to make decisions on their behalf. So, what does that mean? This means that if you are someone who has been nominated as an agent, you will want at some point to take a look at that form. Now, it's up to the person creating the form to decide when they want to give you that document. They might never give you that document, because instead they may have filed it with their bank, they may have given it to their medical providers, and it's not until you actually need to act on those powers that you're learning what powers you actually have. But it is really, 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 really imperative that as people who are putting into place these power of attorney documents, we are having conversations with the people who we have identified as our agents to tell them what our wishes are. Do I want life support, and in what circumstances, and for how long? Do I want certain medical treatments but not want other medical treatments? Do I have a business that needs to be operated if I'm incapacitated? Or is there a certain person that should be contacted? All of these are types of decisions and actions that we can communicate in our power of attorney forms. And so how this works is, if you are deemed to be incapacitated by medical professionals or even by your family, or even if you just don't feel like doing the thing today, you don't feel like calling the bank, you want Zoe to call the bank for you. That's fine, as long as they have the power of attorney forms in place. So what happens is the agent contacts the institution. They say, I'm Whitney. I am the agent, the power of attorney for Jeffrey, my husband, and I need to access the bank account. I'll probably have to go in. I'll probably have to show proof that I am who I say I am. And also, I'll need to present a copy of the power of attorney form, or if they have it, great, then they can pull it up. Same thing with medical institutions, is that if you want to be able to have conversations with doctors, if you need to make decisions regarding medical care or insurance, they're going to need to have that healthcare advance directive on file. So if the agent does not have a copy, then you need to make sure that you've somehow provided a copy to the medical facility, or that you've left a copy of that document where the agent can find it. All right. I've talked a little bit about this, the court appointed roles, the guardians and conservators. What's really, really, really key to know about these roles is that anytime you're appointed by a court, you're going to have very, very strict responsibility and standards for reporting. For the conservator in particular, because we're dealing with money, it is a very high standard. You must report annually what the ward, so the person who you're helping, what their financial and property situation is. Because the court is going to be monitoring that from year to year to make sure that you aren't taking advantage of them. You're also going to have to ask the court permission to do anything with the principal of the estate. So the principal is something like the home. If you need to sell the home, or even if major repairs need to be made to the home, the conservator has to petition the court to get permission to do that. As a guardian, you're also filing annual reports, basically reporting on how is the ward doing. Are they receiving the health care that they need? Do they have friends? Do they have social events and activities that they can participate in? That type of thing. An administrator is also a court appointed role, and this is basically a version of a executor, except for you are called the administrator when the person who passed away did not have a will. And so what happens is, if you pass away without a will, your estate does still need to be probated. The way that it happens is slightly different because you have not left any instructions. So the court is going to try and identify who would be a good administrator to take care of that estate. If you're appointed to be that person, then you are going to be doing everything that an executor would be doing, but you'll also be, you won't have the instructions. So you'll be relying on the court more to tell you what to do and when. There are many times where, as one of these fiduciaries, you would not have liability as long as the actions that you're taking are within the scope of your duty to basically have the best interest of the protected person in mind, so the incapacitated person. However, because you are a fiduciary, you do have significant responsibility to protect the assets of the person. So this means that if you have been identified as somebody's agent, but you suck at handling money, or you don't think you're going to be able to do the role in a way that will shield you from any kind of liability if something is done wrong, then you should have a conversation with the person who appointed you, because you just may want to think twice about that, because you can be held liable, personally liable, if you mess something up. Now, we do have some safeguards in place. One of those is generally a court appointed fiduciary, so the administrator, executor, conservator, they have to buy insurance, which is called a bond. They have to buy insurance so that just in case they mess everything up with the finances, there is money that can reimburse the estate and the beneficiaries. But there are other times when there aren't really safeguards. The safeguard is the threat of being held personally liable for whatever action or inaction that you took that put the estate and the asset or the ward or the person at risk. So just keep that in mind. And when you're picking somebody to be a fiduciary, keep that in mind as well. Are they responsible? Are they reliable? How are they with money? Do they manage their own affairs in a way that is admirable, or at the very least, like, are they straight, right? Like, do they got their stuff together, or are they a hot mess? Are they, you know, do they handle their affairs in a way that you agree with? Because you're going to be asking them to handle your affairs, but if they use some type of accounting system, or if they rely on credit cards to get the air mileage points and you don't like operating like that, then have a conversation and make sure that they're the right person for that. Okay, so when I talk about this playbook for a fiduciary, what is really important for you to understand is that the playbook is in the communication. It's not something that I can give you or any one attorney can give you. Um, it is a conversation that you must have with your loved ones. And in my opinion, this is the responsibility of both the people who are being nominated to serve in the estate plan, but very importantly, the people who are doing the nominating. So if I have chosen an executor, my thought is that I need to be confident that the person can do the job. I need to make sure that I can answer any questions that they might have for me or point them in the right direction to get additional information. Okay? We can have all the documents that we want, but if we haven't talked about what it is that somebody is supposed to do or what our goals are for our estate or our legacy, then it's very possible that the estate plan falls flat. So choosing who is going to have a role in your estate plan can really make or break that plan. Here are some questions that I suggest people have to kind of launch the discussions with loved ones. So if you became incapacitated, would you want to stay at home or would you want to go to a nursing home? This is a question that we do talk about in Black and Brown families because we do like to take care of our people when we can, but thinking logistically and practically. So if my mom wants to be at home as she ages and if she becomes incapacitated, what am I going to need if I am expected to be her caregiver? How much money am I going to need? What is the space that I'm going to need in my home? Are different not accommodations, but different like dang, what's the word? Am I going to have to make structural changes basically to my home to make it so that my home can support a person that maybe has physical needs or um, even like line of sight? Do I need to knock down some of these walls so that I can see somebody that I'm a caretaker for? If I am going to be somebody's executor, then do I live in the same state? Is it easy for me to get to that city or state where I'm going to need to probate the estate? Do I have the money to do that? Do I have the flexibility from my job to be able to take several hours, maybe once every few months? Knowing that here in Fulton County, probate, the average length of probate is 2 years. So some additional questions, what can we do to make it easier for you as you age? Do you want to be on life support? Why or why not? What's important to you to happen in your last days? What do you fear happen? Uh, what do you fear happening? I think this is a really great question because it can let us know what our loved ones do not want. Like I fear that I'm going to die alone. Okay, so they do not want to be by themselves. Um, and these questions aren't necessarily going to get to what the role of the person is, but it's going to give you way more information about things to keep in mind for caring for your loved one, whether as an agent or as an executor or trustee caring for the estate. So when we're talking about just the incapacity and long-term care, so whether or not there needs to be nursing home assistance, the people or the roles that are implicated in this kind of decision making are the power of attorney agents, both the financial and the healthcare, primarily the healthcare, but also to the financial to the extent that assets need to be sold to be able to support financially whatever the wishes are. The executor of the will is not doing anything at this stage because the will is not really active until after the person has passed away. But the trustee, the successor trustee of the trust, may have work to do. Now, they don't necessarily need to disclose the contents of the trust to anyone, but they definitely should be notified because they may be acting in their successor trustee role to help with the management of the funds and distribution of funds during this time. Okay, what do you want the end of your life to look like if you are ill? Do you want life support terminated and when? What is important to you to happen? These types of questions and this kind of discussion would be great for somebody who is the healthcare agent under a healthcare power of attorney or advance directive. Communicating around life support is really critical. Communicating around the type of treatment preferences that you have, communicating around your final days, what do you want that to be like? Do you want to pass away at home? Do you care where you pass away at? Do you want to be buried in a different state? If so, where the money reside? Like, how are we getting you there? Who's paying for that? Is insurance covering that? Those are like the real logistical and practical questions that we should be asking. So again, it's not about the documents, it's really about the conversations that we're having. The documents support your goals, and so they should always reflect what your goals and what your values are. If your goals change, that means it's time for your documents to change as well, or at least for there to be a review of your documents to make sure that it's still in line with what your new goals are. All right, so that is the end of the formal presentation. If folks are interested in getting some estate planning done, because maybe you've heard something in this presentation that makes you feel like you need to update or revisit your estate plan, I welcome you to reach out to us and schedule a complimentary legacy planning meeting. If you do not have a plan and you're realizing that you need a plan, then similarly, I welcome you to reach out and schedule a complimentary legacy planning meeting. You can do that by scanning this QR code. This is a 60-minute meeting that allows me to get to know you, to get to know what your goals and your values are, and to start the discussion with you around whether a will or a trust is going to help you achieve those goals, or if there's some other estate planning solution that can help you achieve the goals that you have for yourself, your legacy, and your family. What will happen during that meeting? Like I said, that's a 60-minute meeting. We will talk very concretely about an estate plan for you. If you decide that you would like to move forward with estate planning with Wills for the People, and you become a client, we will then do a 2 to 3 hour design meeting. And during that meeting, we will actually be putting your plan together. You will have opportunity to review your estate plan documents in advance before we sign at the signing ceremony. Steps 1, 2, and 3 are all virtual. So we would do that over Zoom. And then if you were somebody who did not want to use Zoom, there is opportunity to do that. But there is a virtual opt-out fee that you will be assessed. And then the signing ceremony happens in person. One of the things that I pride myself with as I am working with my clients is having a relationship based interactions with my clients. I am less transactional, and sometimes to my detriment. We really value education because what's important to me is that you know what to do, that you know how to operationalize your plan, that you know some of the key decisions that you'll need to be making, and that you're able to communicate that effectively. So sometimes that means we are able to spend more time with you to explain things or to explain things to your family. It's really important to me that you understand what we're doing here. We also take a proactive approach to planning in that I want to know what your family is like and what the relationships are like in your family so that as we're putting your estate plan together, we can make sure that we're taking that into consideration. And then lastly, our services are flat fee for estate planning. This is a look at our breakdown of services. Um, it says 10% off. I'm not offering 10% off. The 10% off was for people who watched the recording or the webinar live on Black Friday. But these prices are good in that I have a three-tiered plan option. The gold plan that features the revocable living trust and the will is our most popular plan. That is the plan that you want if you want to skip probate. Okay. That plan is 4,000 for a single individual and 5,000 for a couple. If you have a family and you have young children, there's a different pricing structure because we also want to make sure that we're getting you a standby guardianship designation, a power of attorney for the care of a minor child if needed. So there's some additional forms in planning that we do when we're planning for what should happen when we have young children. And then lastly, I'm recording this on Small Business Saturday. I invite folks who want to get started with organizing their affairs to pick up a copy of my workbook. I planned for this. This is a 100-page workbook that allows you to record the important information about yourself that you would want your loved ones to have so that if somebody needed to take care of you, they could. They have all the information. Our holiday deal right now is getting 40% off the cost of the book when you buy 2 or more. So to take advantage of that, you can enter in the code Fiduciary Playbook 40 on my website, which is www.willsforthepeople.com/products. Okay. So you'll add 2 or more to the cart. And then when you're ready to check out, you can enter in that promo code through December 12th, 2025. Okay. Thank you so much for your attention. Please feel free to share this presentation with your loved ones. It is so important that we are having this conversation and that people know what to do when given the role of a fiduciary in somebody else's estate plan, and also that we are keeping these things in mind when we are appointing people in our plan so that we can make sure that our plan can accomplish what we need it to accomplish. Thank you so much.